Good morning. Aribam Scor Sharma from BCom FNA and Anuraj Pradhan have created this Citizen Digital Data Protection and Transparency Act. It involves various chapters which we are going to discuss and finally conclude why is it important for our country. Firstly, the preliminary of this act is that citizens shall gain their digital data protection and transparency, which requires various extent and commencement. We have called this act the Citizens Data Protection and Transparency Act 2025. It establishes a comprehensive legal framework governing the responsible handling of digital personal data within India. It applies to all entities, which include both public and private processing industries, and also other industries in cross border, which ensures accountability and prevents any form of evasion by offshore entities. Nextly, the as we are going to discuss this law, I would like to talk about this law's application. This act governs all form of digital personal data processing carried out within the territory of India, which includes both automated systems and both non-automated systems in the form of digital records. The act, we'd also like to talk about the act uh, does not apply to firstly personal or any form of domestic use for obviously privacy reasons. Nextly, personal data which is voluntarily made public by data principle. These exclusions are obviously important for any form of regulatory burden. Uh, we'd also like to clearly define before going into the law so it is easier to discuss. Firstly, data fiduciary, which emphasizes accountability of the entity who decides the processing purposes. Uh, also, processing in our context means any collection, storage, analysis, sharing, and all these processes. Nextly, as we discuss the obligations which we just discussed, data fiduciaries. Uh, Firstly, they require any form of fair and law processing. The data fiduciaries we just discussed ensure transparency, fairness in processing, and avoid any form of deceptive or manipulative consent practices. Firstly, notices must be concise, itemized, and in plain language so they are easy to understand and explain various categories of data and provide accessible formats for person with any form of disabilities. Most importantly, the consent of the data must be affirmative and specific to each purposes and revocable at any time. Uh, Withdrawal processes must be uh, processes must be as easy as giving consent, clearly explained with any form of impacts implied. Nextly, data security and a breach notification. Reasonable safeguard includes any form of encryption, access controls, multi-factor authentication, routine security audits, and vulnerable assessments. Breach contract must include any nature of breach, data affected, and remedial actions taken. Nextly, I would like to go on to the various rights of citizens. Firstly, it includes right to access and confirmation of whether data is processed, the clear summaries of the processed data, obviously, and information about the automated data used. Nextly, we have given the right to correct an erasure of data fiduciaries. As we just discussed processing in the above definition at first, the erasure is a major part, and we have decided to give a right. There includes correction of inaccurate, outdated, or incomplete data, erase data upon request unless we legally required to retain it. Nextly, right to grievance redressal. As various acts of their own, such as the Consumer Act, we have also decided of our own Data Privacy Act to have a grievance redressal, which establishes any form of grievances and through portals and any form of helpline numbers. Lastly, we'd also like to talk about the establishment of this authority we would be having. Uh, the Authority of Digital Data Privacy Act, which we have created, includes an obviously a chairperson, and nextly various members of privacy, cybersecurity, law, and technology to ensure all fields are there with various varieties. Powers of the authority which we have decided include conducting inquiries to civil courts, compelling various productions of evidences, and recommending legislative improvements to this particular act. And lastly, going on to the penalties of this act, uh, various exemptions, however, for this include uh, national security and integrity purposes and investigations or legal obligations. I think the following exemptions are pretty much implied, and no explanation is required for it. Nextly, exemptions must be proportionate, authorized by law, and subject to procedural safeguards. The penalties we have decided for each deterrence includes 10 crore for security failures and 5 crore for any form of breach notification. And the overriding effect that this any form of act supersedes conflicting provisions of other laws, which ensures a uniform data protection regime across India. Uh, feel uh, as just we talked about this overriding effect, data this privacy act requires a huge huge requirement in our country, and therefore it is justifiable that supersedes any form of other provisions of the previous acts. uh, Lastly, as I'd like to conclude, I think this law we have created represents a very deliberate step towards strengthening individual rights in a rapidly evolving digital world. As we see in this rapidly digital and computerized area, personal data has really become a valuable resource which is capable of empowering multiple societies. Uh, it acknowledges innovation, commerce, and governance, as we know. Therefore, it is really important. This act seeks to transform the relationship between people, systems that collect information about them. Lastly, I would conclude that while technology will continue to change at a pace, laws are rarely there to match, and we feel that this law just we have created is a important law for ensuring digital privacy and provide a foundation on which digital frameworks can evolve. Thank you so much.